Hello, everyone. I'm Megan Guevara with the Pretrial Justice Institute, and welcome to the fifth session in our What If series, where we're going to be looking at what if we focused on constitutional principles for detention and release decisions. And as many of you know, this series comes from our publication, What If 10 Questions to Spark Pretrial Change. We're actually taking on two of those questions today, where we're going to be looking more at what are constitutional principles related to release and detain decisions. And then how does that intersect with court culture and the decisions that judges and judicial officers are making every day related to detention and release? And we know that this is a question that a lot of you are wrestling with locally. And so we look forward to hearing your comments in the chat. And also, we hope we're going to leave you with some questions today that you'll be taking back with you to your colleagues.
Yeah, thank you, Megan. And I'm Shavante Keaton, also at the Pretrial Justice Institute, and we're excited that you all are here joining us for this important conversation. We also have our colleague, Wendy Shang, who is going to be hanging out in the chat box. She's popping links in as we speak and really connecting everyone to resources. We know the 30 minutes goes by fast, so we don't want you to panic. We will be sharing the resources that are shared in the chat after the event. So please feel free to be looking out for those. But as we're speaking of the chat box, we'd love for our guests to pop over in the chat box now and kind of introduce yourselves, tell us where you're joining us from. And any questions that come up, please feel free to pop those over in the chat.
We're going to be joined in a few minutes by our guest today, Judge Carla J. Baldwin from the Youngstown Municipal Court. But before that, just wanted to talk a little bit about what are we talking about when we're talking about constitutional principles and detain or release decisions. And there's a few different pieces here that often gets meshed together, resulting in one bail decision. But the first is the question of whether someone is eligible for detention. And we have some federal guidelines on this based on Supreme Court precedent. And also states have guidelines in their state constitutions as well as in their statutes about who is actually eligible for detention. And we know that usually there's a pretty significant difference between who the law says is eligible and who's actually sitting in jail every night. So that's one of our questions is how did we get so far away from that detention eligibility net in terms of who's being detained? And then of all those folks who are eligible for detention, how do we actually make decisions about who should be detained? Because not all of those folks need to automatically be detained during the pretrial period. And this is when everyone who's eligible for detention should have their day in court, should have the opportunity to be represented by defense counsel and to have an adversarial hearing related to the question of, is there not any condition or combination of conditions that should allow someone to be released pre-trial? And this is really one of the fundamental questions that we ask in What If. What is the difference between having a culture that defaults to liberty, where you need a reason to detain someone, versus a culture that defaults to the idea of detention, where we need to justify someone's release? So we'd like y'all to be thinking about that today of, what do your laws say about who's eligible for detention? What should courts be considering when making those detention decisions? And what is it going to take to help move us to the place where we really do use those specific limiting factors in making decisions about who's detained and who's released? I think Shavante may be having some
and
technical
as we're talking about
difficulties.
eligibility, sorry, am I back now?
You're back now, yes.
Okay, sorry. Yeah, my internet is giving me a little signal that it's having a little problems, but welcome to technology. But again, as we were talking about those who are eligible for release, that next distinctive component that you'll hear us talk about, and Megan mentioned it a little bit, is determining what combination of conditions or what conditions should be in place where people are when they are released. And we know that the Supreme Court offers guidance that they should be the least restrictive conditions necessary to ensure that folks come back to court, ensure reasonable court appearance and public safety. However, as a field, we really don't know what those least restrictive conditions, what least constricted conditions necessary really means. We typically default to supervision or surveillance, when the legal guidance tells us that we should default to liberty, unless there's a specific reason not to. And so we don't typically differentiate between willful flight and just failure to appear in court. And so we really want to be examining those particular components as we think through what prevents us from defaulting to liberty, even with those constitutional principles and that guidance that we know about least restrictive conditions. So today's conversation is really going to help us answer a few questions of how did we end up with such a significant gap between the intent of our bail laws and our daily decisions, right? So cult culture and judicial practice are both really important components as we think through answering those questions. And today, as Megan mentioned, we are joined by the Honorable Judge Carla Baldwin, who is going to talk to us about the work that she's been doing to make changes in the culture of her local court. So we'd love to welcome Judge Baldwin onto screen. She is the administrative and presiding judge of Youngstown Municipal Court and is the first Black woman who was elected as a judge in Mahoning County. So welcome, Judge Baldwin, to this really, really important conversation. We're really happy to have you here.
Thank you for having me. I'm excited to be here, and hello to everyone. I see we have people from all across the country tuning in this afternoon, so hello.
Absolutely. And so let's jump right into this conversation. So the federal Constitution and the Supreme Court precedent tell us that liberty should be the norm and that detention should be that carefully limited exception. And that most state constitutions offer stringent guidance on detention eligibility. However, we know that many people who are detained pre-trial don't meet those constitutional standards for eligibility. So can you share with us what are the challenges for judges that prevent a default to liberty, to pretrial liberty specifically?
Number one, I think it's just a huge paradigm shift. Yes, the Constitution says that, and we who wear robes, we took an oath to uphold that. But just the culture of what we do says, we keep more people in than we release. So I think what we have to do, the challenge is start asking some pointed questions, which is you may have a significant history of failure to appear. But what were those cases? Were they speeding tickets? Were they murder? And I think we need to get to the root of that. Is there a mental health issue involved? Is there a substance use disorder? Which we know if individuals are struggling with addiction, they're not in their best state. But does that mean they need to be locked up? Is that someone we fear being on the streets? So I think we need to have some more pointed questions. And I think we have to look at our own locations and think about, this is not law and order here in Youngstown, Ohio. I am not taking individuals' passports. They are not getting on private jets. They are not fleeing. A lot of times they just have so much on their plate that they forget. And I always have to think about myself. If I didn't get that text reminder from the doctor's office, how many appointments would I miss? So if I could just extend that same courtesy to an individual before me whose life and liberty is at stake, then we can get to a better result. So most people aren't bad people. Most people aren't trying to ignore the court. Sometimes they just have so much going on. They just need a little more help.
Thank you, Judge Baldwin. I really appreciate those distinctions that you made, which we also get to in What If, of like the difference between someone who misses an appointment with court and somebody who's actually attempting to flee prosecution are two very different things.
Right.
And the difference between somebody who does have a responsibility to the court because they're facing a charge versus somebody who is facing a serious charge where there's a concern for the safety of people in the community are different things that need to be considered. And you also mentioned that culture is really the underlying factor there. And as a presiding judge, what do you think it takes? What are some of those key factors to be able to make culture change within a court?
You have to be intentional. I always say I've wanted to be a judge since I was 12. I've yet to meet an individual who said I wanted to be a defendant when I grow up. And so I think we have to treat everyone as an individual, not a case number or not an allegation, which is what the charge is, and get back to that whole notion of innocent until proven guilty, and do a little deeper dive and to say, why are they here? Again, why do they have 2 or 3 failure to appears in their history? What is the actual risk of violence or future violence in the community, if any? And then you encourage your team to do the same and give them the authority to say, you decided this, but I think this. And this is something, a culture that we've worked really hard, that I've tried to instill here, that everyone has a voice when it comes to pretrial, and we see things differently. And so I want to hear the perspective of my pretrial services officers, but I want people to be treated as people, because that is what they are. Just because they may wear orange, just because they may be temporarily in the county jail, they are still an individual. They're still someone's child. They're still someone's parent, and they deserve that same care, courtesy, and regard that I would want if I was wearing orange instead of black.
I appreciate that point about humanity that we need to be reminded of so often, for everybody that comes in contact with the system. And are we at every step taking that intentional treatment of folks and remembering their humanity? Thanks for raising that.
Absolutely. And also that piece about voice, right? We talk a lot about voice and making sure that folks' voices are heard in the space of pretrial, and that it's not just the court or court officers who are speaking on behalf of what needs to happen for a person who's come in contact with the system. So I think that's really important as well, that you raised, just being able to hear the voice and hear from the folks who are being impacted by those decisions.
Right.
And so we know that municipal courts are often the front line for people in the community who have significant needs that bring them into contact with the criminal justice system. And jail becomes sometimes the answer to the problems that they're facing. So what resources would you like to see, Judge Baldwin, in the community that reduce the likelihood that people will in need will need to face, will actually have incarceration be something that they deal with?
I think what we need is, we are very resource rich in Mahoning County. It is a true blessing. What we don't always have is a connection. I was in a meeting one day, and an individual said, we have everything we need right here in this room, but we have to do a better job of connecting the dots. So I think that's the challenge, and to understand that individuals are fearful when they come into the system. And I don't care how often they've been in the system, so many individuals are truly ignorant as to the actual process of what occurs. And so there's defensiveness. And so I think when you have exceptional pretrial service workers who connect with individuals and say, I'm here as a support. Don't see me as a pain. I'm here to get you connected. So hopefully by the time you appear in front of the judge and your case is resolved, we've got new employment. If there are mental health or substance use needs that need to be addressed, we've hooked you up with a resource, a provider for those things. And we're here to let you, to tell the court all the good things you've done, that when you're supposed to call in, you've been calling, and when you're supposed to get somewhere, oh, guess what? The bus here in Youngstown, Ohio, you ride for free. So let me give you the app so you know how to use the system so you can get to all of these places. Here's resources for housing and rental assistance and all these things. So let's help people. So what I would like to see more of, and I'm happy to say, we just got word, we got a grant from the state of Ohio that we'll be actually able to hire a pretrial services officer who we kind of want that to be their focus. Let's help you connect these dots. So all these things that you're deficient in, we will be able to assist you at the court to make sure that you're better when you get out, because these individuals are my neighbors. And I want my neighbors to be happy and healthy and be able to be engaged in the community and pay taxes and give back. And so I see pretrial as a supportive arm that will ensure that court appearance keep the community safe and then result in a better individual, which means we all win.
Absolutely.
It's honestly unusual that we hear someone say like, oh, we feel like we have the resources that we need in the community. That's fantastic. And that is such an important point about how to make those connections with a lot of very complicated systems.
Right.
And I think in addition to what you raised around once somebody comes in contact with the court, how to make those connections also then how can we potentially make those connections beforehand if
Right.
those were some of the needs that drove people to the court system in the first place. Um, and one of the trends that we're really excited about is more pretrial systems having conversations with people in the community and asking, what do you need? What both once you are touching the system, but also to be able to prevent that contact in the first place, and how do we create space for solutions that are being driven by community members. And so we'd love to hear more about how your neighbors in Youngstown have influenced you in your court, and any thoughts that you have for local courts that are trying to make stronger connections with the community.
Well, one of the things that we did, my court, we were a learning site for APPR to implement the public safety assessment as our risk assessment tool. And through that process, and we just completed that in June, we decided to engage the community as a part of that process. And so we had stakeholders, I believe about 30 stakeholders, victim advocacy, initiative to reduce violence, mental health board, our substance abuse clinics who work for our community. We had public health. We had all these individuals who do all this work. And we sat around the table and we talked about the challenges of pretrial and how we can best resolve these issues by, in effect, creating a system map and understanding what each other does, so that while we are all independent, how we can work better interdependently. And so that's been a huge help, because now these stakeholders who have always been at play in the community, but never at the same table at the same time, we were able to do that. So what we now know is that we have this resource, so that when an individual is assessed and they do share with the pretrial services officer, this is my challenge, we have community entities on board that say, hey, send them my way. And they understand what pretrial is at Youngstown Community. They understand what we're trying to do. And that has been a tremendous help. And I also have to say that we've been working with our Latina organization here, who has sometimes not had a good relationship because of the true language barrier for individuals who are not native English speakers. And so I went and sat down with my court admin and we met with the executive director. And since that time, our whole pretrial and probation team have built a relationship with the social worker there. So we can learn how we can assist those who don't speak the language, but who still need the help. So I would say for anybody on the call who's interested in creating or improving, go out and build those networks. And when your court may have been deficient, just own it, say it wasn't intentional, but we're trying to improve this thing so that we can help people, which is everyone's goal. I think you'll be amazed at the results. And I've been so pleased, and I don't think ever before in this court's history do we have so many community entities coming to us saying, how can we partner with you to help those who come through your door? So that's one thing I'm very proud of.
I love that. Just own it. We need to acknowledge the mistakes in the past, because there have been a lot of them in how our systems interact with the community, and that this is a chance to own it, take responsibility, and move on. And I appreciate your points of, what are those barriers to making sure that the community is able to be engaged? And some of them are historical, some of them are logistical, some of them are about trust. And it's not just a matter of saying, oh, well, we invited somebody to the party. It's a matter of, what does it really take for somebody to feel welcome and included in these processes as they've happened. And it sounds like you've taken some steps to be able to do that.
Thank you.
And I loved hearing about the emphasis on collaboration, right? Like recognizing that there are so many agencies or stakeholders who all impact folks who come in contact with that criminal legal system, and being able to be at the table with one another, collaborate, and have those shared goals to better outcomes for the folks in your community. I think that's a really important point as to how we can continue to see those better outcomes, and how important collaboration and conversation and community is in that process. So I really appreciate you lifting that up.
Thank you.
Thank you so much, Judge Baldwin, for joining us today. And you've definitely generated a lot of conversation in the chat. Thanks to everyone who's been sharing their perspectives. And we know that so many of you are dealing with these same kinds of challenges. So we're always happy to connect with a judge who is working at this every day. And thanks for sharing what your experiences have been in Youngstown.
Thank you so much for having me.
Absolutely.
Okay. All right.
Thank you. Yeah, this conversation, as we spoke about, we know so many places are dealing with, these same issues. And we know in a 30-minute conversation, we don't always get to all of the things that we're thinking about, but it's really great to continue to have this conversation about constitutional principles and aligning with strict constitutional principles and when we do align with those constitutional principles around detention eligibility, we can reduce jail populations. We can see that happen, but we have to be really careful with those incidents that we see of misalignment with constitutional principles when it comes to pretrial detention, because we know that if we don't honor them and adhere to them, we can have what we call net widening, right, Megan, where we're bringing in more people into the system because we aren't respecting that guidance around detention eligibility and what the least restrictive conditions to ensure court appearance and public safety. And so it's really important to remember that because we don't want to widen that net, and we don't want to increase incidents of racial bias that we know exists in our system. So really having this conversation about that return to constitutional principles and that adherence is really important, and that we know as a part of this conversation around detention and detention eligibility, that money comes in. And we know that there isn't evidence, there's zero evidence that money reasonably assures court appearance. And so we really want to keep that in mind as we're talking about, and that's the reason that we're really kind of returning back to those constitutional principles, because that's really what gives us that guidance of what detention eligibility we should be considering and what are the conditions that are least restrictive to ensure that folks come to court, don't flee from court, but also to make sure that the public safety concerns are addressed as well.
And also the safety of the people who are facing charges as well. That was the focus of one of our earlier events, that we want to make sure that people in the community are safe, but we also know that detaining someone subjects people to a lot of unsafe conditions that are important in that consideration as well.
Absolutely.
And so 30 minutes is not enough to explore this topic in depth, but we did want to leave you all with some questions that we hope will be conversation starters for everyone back home. And then we also welcome you all to continue this conversation with us over social media or to reach out to us around any of these questions. But really, the first and foremost, what does your Constitution say about who is eligible for detention? And what are the safeguards that are in place to make sure that other folks are not ending up in detention by default? As Shavante mentioned, making sure that it's not because unaffordable money bonds are keeping people in detention, that risk assessment tools are not being used for detain or release decisions. It's not what they're intended for, or that there's not other criteria that are then catching people in that detention net. So do you feel like you've got a really good handle on what your state law and constitution allows? And are you seeing a gap between those standards and the folks that you're detaining?
Absolutely.
And then what are your processes for making detain or release decisions? So what determines whether somebody is actually eligible for preventive detention? And does that person have defense representation? Is that a full separate, distinct adversarial court hearing? And in many parts of the country, it's not. And so detention does become default, or in some places, there are decisions made about detention where the person facing charges doesn't have representation. So do you feel like those hearings are meeting the standards in your community? And if not, why not? And what are the opportunities there? Okay. And then there are the two standards. Shavante talked about the distinction between willful flight and non-appearance, and Judge Baldwin mentioned that as well. Like, are you really able to get into the difference between, did somebody miss an appointment today, or is somebody trying to flee prosecution? And both the way those are measured and the way they're considered in court. That at the end of the day, we're trying to keep people from fleeing prosecution, and that doesn't really happen very often. And if your Constitution allows a standard of dangerousness, which not all do, who gets to decide what that means? Are detention hearings being held to interrogate that position? Because it is a very legitimate concern that, Shavonte, you mentioned net widening. This is definitely a place where net widening can happen, depending on who's defining dangerousness and what's considered dangerousness in your community. And we don't have a standard to look to necessarily. This is something that places define and interpret in different ways, and something that we need to understand more, both for willful flight and dangerousness. And then when setting conditions of release, what does it really mean to set the least restrictive conditions necessary? And unfortunately, we don't have a lot of data to guide us about what is the effectiveness of different conditions at different doses at different times. And are we able to default to liberty unless we know that a particular condition is necessary? So these are some big questions for our field. They're questions that we're struggling with at PJI. We know they're questions that a lot of you are struggling with. But if we can get to the point where we're able to say people are only detained if they meet those very rigid criteria, and people are only given conditions of release if those conditions are individualized and if there's a very specific reason, we will have a lot more freedom in our communities. We'll be much more aligned with what the constitutional intention was for pretrial release. And then in our upcoming events, we'll be talking more about, okay, then what are the supportive services that are needed in the community to support safety and return to court? Because those are still important considerations, as Judge Baldwin mentioned, but we just don't necessarily need to achieve those through detention and surveillance.
Absolutely. Such food for thought for folks. So we hope that those questions will generate some really great conversation for folks as you leave this event, and to continue to have those interrogations in your sites and the places in which you work. And so we know it goes by fast, but we want to thank you all for joining us. We want to give a special thank you to Judge Carla Baldwin for joining us and really giving us that judicial perspective about these constitutional principles that we're talking about. And I also want to thank our guests, because we see some great things happening in the chat. Folks have been putting links in there and sharing really great resources. And as we shared, we will be sending out follow-up emails with the things that are shared in the chat. So we don't want you to think that you're going to lose this valuable information and these resources. We will be sending those out. And we do have one quick announcement. So we have just a few spots left in our upcoming 6-week pilot course on the fundamentals of pretrial, which starts next week. I'm really excited to be one of the co-facilitators. And it's an amazing opportunity to dig into some of the issues that we've talked about today, and to connect with folks from all over the country who are doing the work, the same work that you're doing around the pretrial system. And so we invite you to click on the link in the chat that Wendy Shang just shared. Again, it'll come out again. And we also want to share that there will be a really special event in November that's also going to be coming to your inbox. So please be on the lookout for that. Again, as Megan said, always feel free to engage with us on our social media and our website. And we really look forward to having our next event in November. So thank you again for joining us. Thank you, Megan, for, as always, such thoughtful conversation. And we look forward to seeing you all very soon.
Thank you, Shavonte. Always wonderful to talk to you. And thanks again, Judge Baldwin, and everybody who joined us today. One more thing to plug. We are also working on a brief on the question of willful flight versus FTA. So more on that. It's something that we're giving a lot of thought to at PJI, and I'm sure we'll be talking to you all more about. Absolutely. And we hope to see you all next month. Take care. Have a great day.